You're watching Signature TV, and recently the Economic and Financial Crimes Commission dismissed 27 persons, and they say that it's bordering on several issues of misconduct, and that's the reason why the 27 members and staff of the EFCC were dismissed. We're going to be x-raying that with a beat of finding out if, for instance, if that happened over and over again, if Nigerians will see the EFCC in a totally different light. We have with us live in the studio Barrister Godwin Onwusi. Good to have you. Good morning.
Good morning,
Charles. Good morning, Nigeria.
Happy New Year.
Same to you, my brother.
Okay, I mean, the EFCC is in the eye of the storm this period. Not just even about these 27 persons who have been dismissed, but there are other things that have happened in the past where EFCC, would try to, recalibrate themselves to the point of making Nigerians see them as an anti-graft agency that can be trusted. With these latest developments, what's your take on it?
I think it's good to start from the history of the EFCC itself. The EFCC is a brainchild of then President Olusegun Obasanjo. He sponsored an executive bill that metamorphosed into the EFCC Establishment Act 2004. And that act gave the EFCC very wide powers with regard to fighting corruption. It gave them the power to investigate economic and financial crimes, to enforce rules and law regarding economic and financial crimes, and then to prosecute offenders of economic and financial crimes. With this, you find operatives of EFCC coming in contact with highly exposed political office holders, because those are the people actually that the act actually came to assist the government in fighting, because of the tendency for people to pilfer public funds. So in the course of it, a lot of them get involved in because of meeting these people, there are tendencies for there to be temptations. Because when you're dealing with a governor, a past governor who has amassed a lot of wealth, a senator, a minister, there's a tendency for them to tempt some of these operatives. And then human beings being what they are, and then that EFCC as an institution being part of the society called Nigeria, there are bound to be some bad eggs, just like you have in most establishments. So I think it is those bad eggs that have now been identified, some of them, because a lot of times you find a lot of EFCC operatives living conspicuously above their means. And these are products of corrupt tendencies, because a lot of things they do are not things that they get from their salary. A lot of times in Nigeria, a lot of people keep asking the question, who will watch the watchdog? Because EFCC is the watchdog. And the law establishes, gives EFCC itself self-cleansing mechanism by way of administrative ways of cleansing what they do. I think it is that self-cleansing mechanism that they have applied in identifying those 27 people. There are still many within the system. And this step, I think, will begin to give Nigerians more confidence with regard to EFCC, because a lot of people had lost confidence in EFCC as an anti-graft agency because of certain things, corruptive tendencies. Maybe with this, with the new helmsman there, Olukayode, I think Nigerians might begin to have a rethink about the fact that a lot of Nigerians have written off EFCC as an anti-graft agency prior to now.
Interesting. So now that it has happened, the next thing would be whether they would also change, in their actions and activities. Because like you mentioned, these people get exposed by the virtue of the fact that they're dealing with those who have been exposed to government officers. They will be exposed to politicians as well. I mean, like you noted that some of them live way above their means. You can't be having somebody earning as low as 250 or 200,000 in today's Nigeria, and you're having them drive Benz, having them drive, even ML 350, these days. But these are what happens, around town. But there's even one other issue that is that keeps coming out: the way and manner that they go about arresting other people, like the Yahoo boys. I mean, there's largely no week that passes without them announcing they have raided a place, they've knocked down the place. And even recently, we heard about the invasion of a radio station in Enugu State, how they went about it and the manner that they went about it. Do you think that, the EFCC should try as much as possible right now to start thinking of training and retraining of staff in the way and manner that they engage, with people, with a view of at least being professional in discharge of their duties?
There is actually need for them to keep training and retraining. There is no end to education in every facet of life. So retraining their staff with changing circumstances is actually required, especially with the way they relate with the people they watch. Especially with the way they relate with the people they watch. There are certain overzealous people there who could go beyond the limits of their powers in excess, because whatever they do, people still have their human rights guaranteed under the Constitution. In the course of their doing their work, they must be cautious about infringing on people's fundamental human rights, because a person is not adjudged guilty until a court says so. And there is another aspect of it that is exposing the people to this kind of situation. The principle of plea bargaining that came into the prosecution process, I think it was in 2015 that the National Assembly passed the Administrative Criminal Justice Act, where the principle of public bargaining came in. Prior to now, I think it was existing only in Lagos State that had ACJ Act 2011. So that plea bargain is a kind of arrangement between the person prosecuting and the accused person, where the person pleads guilty, and in this circumstance returns a lot of the booties, a lot of what the person is accused of having stolen for a lesser offense, or for that is the principle. Because the rationale behind it is, I think they are thinking that there is no need for somebody who has stolen 1 billion naira to just go to jail alone and then come back and begin to enjoy the 1 billion. So if there's an arrangement that will bring this person to return that money or return substantial part of it for a lesser offense, so that the society at large can get back the money that was taken from the public tilt. That is the sense. So in the course of this plea bargaining, some of them still get some corruptive influences.
Okay,
that's my take.
So the dismissal of these officers, does it show a weakness in the EFCC system?
I don't think it shows a weakness. It's a part of the society at large. In every system, there must be some bad eggs. What is important is for you to identify those bad eggs and give them the treatment that they require, so that others will no longer do the same path. It will be a kind of discouraging effect on other operatives who are yet to be caught or who have been behaving well.
Interesting.
One would have thought that, these things come with several processes. Would you think the dismissed staff have any legal defense to that? Because to the best of our knowledge, it is an internal thing, and there hasn't been any other law enforcement agencies that were used for that investigation. And so sometimes if EFCC wants to do something, and maybe if you have somebody who is targeting you for dismissal, I mean, some things can go wrong in your, against someone. So do you think there are legal procedures available to those who have been dismissed to seek redress if at all they feel that they were dismissed unlawfully?
I don't know the details for which they were dismissed. Even if I knew, I'm not holding their brief to give them legal advice on what to do. But I do believe that just like this your system, when you came in as an employee of Signature TV, there are terms and conditions of service. There are equally disciplinary procedure that you know about. It applies to EFCC. They have disciplinary procedure. As long as they follow that disciplinary procedure, and then these people find themselves wanted, and I don't see EFCC trying to do a kind of crying wolf where the one doesn't exist within their ranks. They must have convincing evidence to be able to give these people the kind of discipline they gave to them.
Interesting.
Okay, so recently we heard about the $400,000 claim about somebody within the EFCC that may have collected. Do you think there are legal implications arising from this particular claim, and to what extent?
Actually, I'm not very seized of the full facts about that $400,000 claim. But I do know that the release or press release from the EFCC spokesman said that the establishment is still investigating and looking into that. We look forward to what they will come out with. Maybe another set of people will be involved. Okay. I will get to know.
Okay, so what exactly are the legal obligations of the EFCC in ensuring public accountability and transparency in its operations?
That's what I'm trying to tell you. The law gives them wide powers. One, to investigate economic and financial crimes. Both those ones contained in the Establishment Act and the economic and financial crimes contained in other laws existing within the country. Investigation of economic and financial crimes. The next one is if there are laws and rules regarding economic and financial crimes, they have the powers to enforce those laws and rules. Another one is that they have power to prosecute people accused of economic and financial crimes. So it's a very wide-ranging. So in the course of these three powers given to them, they'll touch almost all facets of Nigeria because it's economy and finance. I think they are the life wire of any country.
Okay.
So many persons have accused the EFCC of not really doing so much when it comes to investigations. That's the reason why they have consistently lost so many, cases in court. Do you think that the EFCC needs a little bit more experienced hands in the way and manner that they go about their investigations? Outside the country, you hear investigations that people, the investigation organization finishes their investigation before they go after the person. So when they are presenting the things to you, you are just basically corroborating what it is because they've already done everything that they needed to do. But in this climb, we see a situation where they first of all arrest the person before they start the investigation, and that has led so much time for them, losing some of these cases. Do you think that there should be a change in the way and manner that they go about their investigation so as to actually keep up with, the changing times?
Yes, I agree with you entirely that a lot of times they engage in media trial. I don't know whether they want to use it to impress people, but the thing turns out the other way. Because they are engaged in investigating highly politically exposed people who have connections, it's always better to keep quiet and investigate before you begin to invite the person and begin to make noise about the thing. When you make noise about the person is highly exposed. Before you know it, the person will have plugged all the evidences you are going to have. And the court convicts somebody based on the evidence before the court. By the time they go there, they may not have evidence. Even those who are going to come to give evidence again, the people may have bought them over or send them abroad, send them to where you cannot get them. So that's why it is better for them to do their investigation first, follow somebody. In other crimes, developed crimes, you see an investigative establishment investigating somebody for close up to 5-6 years. By the time they come to that person, it's established. The person has no way to hide. But here, when they shout, this person come, this person come, this person come, the person has lieutenants. Before you know it, the person plugs all the loopholes. And that's why they... But all the same, it is still, they are still growing. Remember, they came to the fore after 2004, the Establishment Act. So it will take them time to grow and then mature to that kind of investigative, good, compact investigative establishment that we are looking forward to.
Some people also say that the reason why they have lost so many cases is because some of even their lawyers that they employ are even sometimes culpable. A situation where you see a glaring case, you are sure this is someone that has got into the net, but all of a sudden you see them losing the case. Some people say that this investigation should go beyond just their staff who have been caught to have embarked upon a misconduct during the course of their duty, but even those that they employ as lawyers who are out to investigate highly exposed people, they should also be investigated, because some of these cases that have been lost maybe because of sharing some detail with those who are also involved.
Yes, I agree with you. There are instances, there could be instances where such things happen, because that's why I told you that people at times say, who will watch the watchdog? And no other person that will watch the watchdog apart from the watchdog himself, which is the Efcce that we have. There are some cases where you will have thought will go otherwise. Some underhand things could happen. There could be some compromises here and there. That's why I said that even before, because the lawyers are to prosecute the matter, not to investigate. The issue of trial should start when they must have gotten all the facts they have. So if they don't have a good fact about somebody, they leave that person, and the person will continue to live his or her private, normal life until have evidences against the person. I won't tell you that even some of the lawyers who prosecute the matter do not compromise. That's why I'm telling you, there are bound to be temptations because of the kind of highly exposed people they deal with. So there is need for them to watch themselves through their self-cleansing mechanism. That's the only way. You cannot say you're going to establish another establishment to watch Efcce. Then you continue to establish, institutions ad infinitum.
In the case of Yaya Bello, who was invited severally and he never showed up, and even when he showed up with his governor. and sometimes people say that his governor's immunity covered him to that extent, but he's not. But if you look at what happened in that matter, even the Efcce chairman came out and said that he wanted to give him a special treatment. Do you think that Efcce should be giving people special treatment, given that we've seen them, engage in some of these arrests, especially even with the Yahoo Boy, Bobrisky incidents and the likes? They tend to be different depending on the person. What's your take on that?
That is wrong. every individual is supposed to be equal before the law. I did not hear the chairman of the Efcce say he was going to give him special treatment. But if he said it, it was wrong.
He said it. He said that he even told him to come through the back door. If he's coming through the front door, would be a problem. It was his press conference that he gave.
Possibly I have lost this thing about. But the issue about the thing about that Bello issue is that just like I was telling you, doing media trial will not help EFCC. The man was tactful in the country. I'm sure he was doing everything to plug all the loopholes before coming to show up. Bet you, by the time they go in there, they may not find evidence to nail him. And that's why they should have kept quiet without going to shout. Investigate him, get everything before then inviting him. They invited him, he stayed away, was around. There's no way the governor's immunity will have covered him. But the governor, it was alleged that when they tailed him to the Kogi house, as it was in Abuja in Lagos, that he was there, they knew he was there. The governor came in there, possibly went into the governor's car, and then they drove. That is the allegation. You wouldn't tell the governor, stop, let me search you. They wouldn't do that. That is the extent to which that immunity may have covered him. But it won't cover him forever. Even the governor himself, when he comes out, will lose the immunity. If there are things he's doing now, they are recording it. But the problem we still have is the stupendous amount of money that these people throw about. I'm telling you, most public officers, when they are there and they are stealing, they are keeping the one they are going to use to block EFCC from getting across to them. So when they see these young men and then tempt them with this kind of money, a lot of them fall.
So what would you say, how would you say the judiciary can actually help to support anti-crime agencies like EFCC maintaining their integrity?
All that the judiciary can do, like a judge, if you were a judge, you are not there when something happened. It is the evidence that they bring to you. You cannot pass judgment based on any other thing. Even if you were a judge, you saw when an offense was committed, and you were there, you witnessed it. You knew that that person committed that offense, and the matter comes to court. And they did not bring any evidence that the third person will say, yes, this person is guilty. You cannot say, hey, I was there when this thing happened, therefore you are guilty. The judge cannot do that. It means the judge is descending onto the arena of the conflict. It must be evidence produced by those who are prosecuting. So that if a third person comes to read that judgment and say, yes, if you're a judge and you say, I saw the person, that blah, 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 and then another person comes, the person will not see that evidence. So all that the court can do is equally lawyers that will assist in doing so. My colleagues, a lot of them cause the delay. A lot of them file frivolous applications to delay, to buy time. And at times, the hands of the judges are tied. If the law says this is this, you cannot change it. You must abide. And then a lot of smart lawyers, follow those loopholes in order to, serve their client.
Interesting.
So all the judge can do is, based on the evidence before the judge, to give the judgment that is in line with the evidence, that is not perverse. Because if you give any judgment that is against the weight of the evidence before you, it becomes perverse. And if it goes up, it will be nullified.
Okay, anti-corrupt agencies like EFCC, they always have whistleblowers. So do we have laws that protect the interests of these whistleblowers?
Yes. I think the whistleblowers became it was during Buhari's regime. Whistleblowers Act was enacted. That's a law protecting the whistleblowers.
And it's effective.
I can't remember the law now. So that when you see something, there were some places that were raided then as a result of the actions of the whistleblowers. So there is law for it. I can't remember the law now. I'll go and look it and find out. What I know that under the Buhari regime, whistleblowers law was passed to protect the whistleblowers and to bring it in, because it wasn't in existence before now. If you're a whistleblower, and then you blow the whistle and something is recovered, a certain percentage as incentive is left for that whistleblower, and the security of that whistleblower is guaranteed because the person's anonymity has to be maintained. But I know it's in existence.
Okay.
Okay, I mean, sometimes so many persons don't know how to reconcile the fact that if you say somebody has stolen 50 billion, and then when you want to grant them bail, you say they should pay a bail of 5 billion, and then they stay and off, and then I don't know. Can you explain to us the system around these bail conditions that comes with when you are here? There now, somebody has just stolen 1 trillion, and then when the judgment now comes, or a bail condition now comes, the bail will be far short of the amounts that they were mentioning. Can you explain to us how that works?
One, the fact that an amount has been mentioned does not mean that that person stole that amount.
Okay.
It is still an allegation.
Okay.
And a lot of times you see these things wide allegations, unsubstantiated by evidence. A bail is granted by court for somebody to be available to stand trial. It doesn't mean that if they allege that you've stolen 1 trillion, that the bail condition should be amount more than 1 trillion. No, that is not it. It's just to give a condition that will make sure that that person is there and you don't just pay that money. Is in case the person goes away.
Okay.
The person does not stay to stand trial, then that money will be paid by whoever is taking the person on bail. Secondly, they have learned there are some other conditions. You submit your passport, you don't travel without permission from the court. All those things make it difficult for somebody to run away from standing trial. So it mustn't be that the money is that they allege you stole 1 trillion doesn't mean that you actually stole 1 trillion. But if the court now comes to the conviction that you stole that 1 trillion, the court will now pass judgment based on what the law provides with regard to whoever.
And sometimes it's the far short of that amount.
It depends on the circumstances of the matter. Depends on circumstances. That's why I'm telling you that the issue of plea bargaining now came in. It's gaining ground. It's a new one. It's gaining ground now. That instead of telling the person go to jail because you stole this, there's a punishment for stealing this, and then the person goes to jail and comes back and then begins to enjoy the booty. If there are ways for the person to pay back that money and have less sentence or less punishment, that is the essence of plea bargaining.
Yeah, but I mean, plea bargaining, is it a national thing, or is it also available in an international system where, for instance, you are alleged to have taken 10 billion? Say, for instance, it's established you've taken 10 billion, and then you come and bargain and say, can I just pay 2 billion and go away with the remaining? I'm just wondering, is plea bargaining a good thing by your standing, by your analysis, or do you think that plea bargaining would, help or even spur more people to steal more? Because I mean, at the end of the day, when I come in and I say, okay, I accept I've stolen, but can I go on to do a plea bargain?
There is actually no system that doesn't have unintended consequences. I don't think that any system or any practice is 100% foolproof, especially in this our climate, where people will always find a way around something. The plea bargain, the essence, just like I told you, is for the society not to lose all. It doesn't mean that that person will not go to jail. Oh. You must first of all plead guilty. That's one of the conditions of plea bargain. You plead guilty. Now, in return for that plea of guilt, the prosecutor will now say, okay, let us remove some of these charges, or let us lower the charge, let us lower the sentence that will be passed. Recommend it, because they don't give it. They can recommend it to the court, and court may refuse, court could accept. And then you pay back that money into the public tilt, because the public now gains. So, but some people could say, okay, let me go and steal, and then I'll come and do this. But it depends on who you are bargaining with, because eventually they know they are not dafts. The bargain will be in such a way that, one, you cannot escape stigmatization as having been sentenced. There must be a punishment. You must plead guilty.
Would you call an ex-convict?
Certainly. But for an offense that is less or carries smaller punishment, and then you pay back money. Paying back money is just part of the one for those who are involved in economic crimes, people who have stolen public funds. You pay back that money, or a substantial part of it, or the one that they have investigated that you have, because they can't find all. It's it's very difficult to find all the money that most public officers have stolen. But the ones the establishment has seen, you pay it back. You have said, yes, I did it. Take this money back. Let me have a less sentence. If it's favorable to the prosecution or whoever is prosecuting, they will accept. But it's a product of an agreement. You now report back to the court. The court, or now on the basis of that, will now pass its judgment.
Is Ojuzo Kalu an ex-convict? What happened in his case? At some point, he went to jail, and it's as a behest of Efcce.
I think his matter, if I still remember, he went to jail. Then technically, in an appeal, that judgment was nullified. If it's the one I still remember, that judgment was nullified because of technical reasons, that the person who gave the judgment had been elevated to another level of the court, and then the person ought not to have given that judgment. I think that was the rationale behind nullification of that that sentence that took him to, that judgment that took him to jail.
How does elevating a judge affect a sentence that has been given?
No. Every judge has its jurisdiction. Every court has its jurisdiction.
But while
if you are a high court judge and you have been elevated to court of appeal, within that time you have been elevated to court of appeal, you come and give judgment as a high court judge. You're no longer seized of the jurisdiction.
But he was the one that prosecuted the matter from the beginning.
That is the position of the law.
No, but if he followed through from the beginning up until that point, I mean, why wouldn't it fall through?
That's the position of the law.
Wow.
It's not meant for anybody. But I know that that's actually what happened in her. That is matter. He was in jail based on that, and then an appeal came and nullified that sentence that took him to jail.
Is that even possible? Somebody has
absolutely
been sentenced.
Possible now.
Somebody has been sentenced and he's in jail, and all of a sudden, why
the
did
higher court
appeal?
has said that that sentence that took you to jail is wrong.
For somebody that's already in jail, it's not like they even appealed while he was around.
They appealed.
He was already in jail.
Excuse me. There was a sentence.
Yes.
And they implemented that sentence that took him to jail.
Yes.
Then, while he was there, he appealed. The Court of Appeal said that sentence that took you to jail was wrong and released him.
It's interesting. But then, don't you think there's a reform around that? Don't you think that something must be done around, reforming our laws, to counter some of these? Because doesn't it feel strange to you?
It's not strange. I'm a lawyer. It's not strange. It's part of hierarchy of courts. A lower court can say this, a higher court will say no. And then a more higher court can now could even say, okay, this thing the lower court gave is correct. This person that said no is wrong.
But in this matter, it's not like it wasn't established that he didn't take money. It was established. You're now saying that it's because that a higher court said that this person that did give the judgment is not supposed to have given the judgment. It's not even about the fact that, you know, he was convicted of taking money.
There's a principle in law. The life wire of every court is jurisdiction. If you don't have jurisdiction to take any step, no matter how good, no matter how sound, no matter how beautiful that step you have taken, it amounts to nullity. It's an established principle of law. If you don't have powers to do something at the time you did it, that thing you did amounts to nullity, no matter how good, no matter how beautiful it is.
So the trial ended like that without any further discussions?
Yes, that is the position as at now.
Wow. All right. This is Signature Morning, and it's quite interesting that we're doing this. But then going forward, what kinds of reform would you like to see in the EFCC? Do you think that some laws should be amended? You said they've given them enormous powers, but sometimes it does look like maybe those powers are limited to some extent. Because, I mean, there are certain things that they are not able to do. There are certain persons they cannot call and question. You know, I was watching a particular documentary, I think it was a few days ago. I saw that the Israeli Prime Minister Netanyahu was still going to court, even as Prime Minister. You know, even doing some war with Hamas and the distraction, you would think that this guy is supposed to have an immunity to focus on defeating Hamas and Hezbollah and the likes. Do you think that some of our leaders should not be having any form of immunity, especially as it relates to financial corruption, so that while they are in office, they know that people are watching them, they can come out and then go to court and then account for the amount of monies that they have spent?
This is Section 308 of the 1999 Constitution, as altered, has conferred immunity to the President, Vice President, governors, deputy governors, while they are in office. The rationale behind it is not to distract them from performing the functions for which they were elected. A lot of debates have gone on the desirability or otherwise of the Section 308, but it is still there. And as long as it is there, the Constitution is the ground norm. There is nothing you can do about it until they come out. That is why the governors, as soon as they're out, they are ready to go to the EFCC, most of them. Because I think I used to tell somebody that a public officer in this country is a potential guest of the EFCC. Every public officer is a potential guest of the EFCC. Others can visit the EFCC while they are in the office. But the president, vice president, governors, and deputy governors cannot visit EFCC while they are in power because of Section 308 of the 1999 Constitution that confers immunity on them in order to stop them from being distracted. That was why it was easy for Governor of Kogi State to have allegedly driven the former governor out of the Kogi house when the EFCC wanted to, followed him there. And according to them, they were sure he was there, but the governor drove in and drove out, and the guy was no longer there.
But even senators, senators loyal to the party in power, You hardly hear them get invited by the EFCC. Some people have accused the EFCC of being a little bit, biased when it comes to the application of some of their activities. You hardly hear them, say for instance, Senate presidents, deputy, they don't have immunity. But you see them not going there. And sometimes they're also looking at the body language of their principal who put them there. Do you think that the appointment by the president, by the EFCC chairman, sometimes skews the mindset of the chairman as to where to go to fight these financial crimes?
We are human beings. And we are all susceptible to human frailties and human inadequacies. I will not rule out the fact that fact, because there is this saying that he who pays the piper dictates the tune. It's everywhere. We may not admit it, but a lot of times it does happen. Even in small establishments, there are people who see things done by their bosses, they look the other way around. It's not only in every, so it's possible anywhere because we're all human beings. And since that provision is there, all we can have recourse to is when the person is out. But while the person is there, EFCC could be collecting their piece of evidence. And when the person is out, or you can no longer call, they will keep quiet and perfect their evidence before telling the person, come. Oh, we have done that. It is this media trial that is not helping them to achieve the length of convictions you have. Then you said something about members of the party in power not being invited by EFCC. I think that is a subjective assertion. People in the other party could say that. But I still know that when Buhari was in power, Reverend Jolly Nyame was a member of the party. He went to jail. He just came out. There are some other people who were members of the party.
But they were pardoned, even by the president.
Who they finished they were in jail. They have been jailed.
But they were pardoned.
I don't have record of pardoning or not, but I know that they went to jail and stayed through.
Two of them, they were pardoned.
And both of them are, I think, Jolly Nyame and Joshua Darie.
They were pardoned.
But they went to jail.
But they were pardoned.
Any other person could have been pardoned. I don't have full record of issue of pardon. I cannot assert it now, but I know that they went to jail and stayed very long and then came out.
That's the issue. Because at that time, I know there was even a debate about these persons are in jail. They have been convicted. And then the president all of a sudden, from nowhere, pardoned them. So the monies that they have stolen is still with them.
No. In the course of it, no. They paid back a lot of money because it was part of the judgment. Then two, the issue of pardoning did not come immediately, if actually they were, because I don't have records. I cannot say yes to it that they were pardoned, but I know they were aware they were in jail for a very long, not less than 3, 4, 5 years before the issue of pardon came up. If they were pardoned, they may have been pardoned at the later part of Buhari regime, okay, if they did.
Are you doubting that they were pardoned or no? Or you are not sure?
I'm not really sure.
Okay.
I'm not really sure.
I think my producers will be able to pull out that particular headline at the time, because I was very, very sure that they were two of them were pardoned, and during the Buhari's...
When you look at it, you find out, well, I'm only addressing the fact that saying that they are not invited is not a correct assertion. That the trial went through, they were convicted, they went to jail. 2 former governors, Jolly Nyame of Taraba and Joshua Darie of Plateau.
This is a 14th of April 2022 headline on Premium Times. Buhari pardons ex-governors Darie and Nyame serving jail terms.
Okay. They were serving jail terms. That is they were serving jail terms before they were pardoned. That is the thing. They were serving jail terms before they were pardoned.
These are the things that people...
And 2022 just yesterday. Yeah. They had stayed long in jail. It was when Buhari was about to go.
They were pardoned.
I know that, in fact, during that period, we also asked this question, whether these guys have been pardoned. Would they be termed to be ex-convicts? given that they have been pardoned by the president at that time?
Pardon means go home and sin no more. Your sins have been
forgiven.
forgiven.
So these are the things. It gives people more reason to want to even steal more. Given that, well, at some point, somehow, if I start playing the cards of the current administration, I can be pardoned, and then I go home and be scot free.
My brother, for them to stay incarcerated for 5 years before that pardon came, they stayed a long time. Oh.
They did.
They stayed a long time. Because it was at this man's second term. They stayed not less than 4 years, if I can remember. If you check that, you will know the details will tell you when they went in and when they were pardoned.
All right.
So I'm only trying to, disabuse our minds of this subjective assertion that members of political party that is in government are not usually invited. But these are facts of people who were members of a party, a ruling party at that point in time. They were tried, they went to jail, and maybe the president just reminded him, these people are still there when he was about to go. Say, okay, go home and sin no more.
You know, the question I asked you about whether the president should be the one to be appointing the EFCC chairman, it cuts across all spheres. Under Barr, who was the former chairman of EFCC, he was at the verge. In fact, at that time, Tinubu was, in APC, and there were this talk about him being probed, being on the list of people being probed. The current Senate president was also on the list of people that are in there. In fact, he was still being investigated at the time Tinubu took over office. And so when you said things like, oh, when people are in the office, the office should be taking records of them, what they do, how they spend money, that whenever they're out, then they can be invited. That may not work. Why? Because as soon as Tinubu took over office, Barr, started running. In fact, he at some point they were even saying that he stole money. They accused him of several things, and largely some persons think that he was in the bad books of the current president, and so there was no reason to keep him. So he was put it out. So if he has a record, or some of Tinubu's allies, you don't expect this person who has taken over to go after those documents. So those are the actions and activities that you see and play out, and you say, is it possible that some other body appoints the chief of the EFCC so that they look a little bit independent, even though we know to some extent they are being influenced by some of these,
I totally 100% subscribe to the view that something has to be done to make the appointment of EFCC chairman, even INEC chairman, to be independent of the party or president in power. As long as it is this way, what we are experiencing will continue to happen until they find a way of making the appointment to be independent of the president or the party in power. There's no doubt that you still say it. He who pays the piper dictates the tune. You cannot, as a human being, it's going to be difficult, except in developed establishment, institutions are stronger than human beings. In Nigeria for now, human beings tend to be stronger than institutions. So when you have those powerful human beings stronger than institutions, the institutions genuflate before them. But when we have stronger institutions that can call the bluff of whoever is the president, what we have is what we keep having. So we have to continue to tinker with a way of, one, making the appointment to be independent of the president in power, and making our institutions to be stronger than individuals.
All right.
Unless and only then can we have a change. But all the same, we are growing. Though you tell me that somebody who is 60-something years is overgrown.
It's overgrown. Should be a grandfather, in fact. But what would you suggest as the body to appoint somebody in the capacity of EFCC chairman? What do you suggest? How do you suggest that they get appointed?
It should be a combination of different bodies. A combination of different bodies having a say in the appointment. Maybe the labor unions, the different unions, civil society, strong civil society organizations playing a role. So that whoever becomes that cannot owe his or her appointment to a particular individual or to a particular government. If such is established, the institution will become stronger because they know they don't need to come and genuflect before the president to be appointed. They don't need to be lobbied to be appointed, and don't need to look at the face of the president to be appointed. It's everywhere. As we are talking about president, you're talking about the governors too. Those appointments that make the heads of those establishments to always dance to the tune of the governors and the president should be tinkered with. There are ways, if we want to do it, it can still be done. There are establishments, there are institutes. If you take NLC, NBA, NMA, all those professional bodies, let them have a say in the appointment of such persons. Then they will be insulated from the influence of the government in power.
All right. Thank you so much, Barrister Godwin, for your insights on today's program. We truly appreciate it.
Thank you.
Thank
My
you
pleasure.
so much.